We have a new filing by Nick McClellan. Let's get into it. State of Indiana, Carroll County. State of Indiana versus Richard M. Allen. State's objection to defendant's motion to suppress filed April 11, 2024. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClellan and respectfully objects to the defendant's motion to suppress filed April 11, 2024, and would ask the court to deny the same. In support of said motion, the state would ask the court to consider the following. 1. The state has provided the defense with statements of Richard Allen. Those statements include phone calls made by Richard Allen to his wife and his mother, and statements that he has made to Indiana Department of Corrections staff and inmates. The statements made to Indiana Department of Corrections staff and inmates, referred to as suicide companions, consist of statements on door sheets. These door sheets are forms provided by Indiana Department of Corrections for monitoring the behaviors and statements of Richard Allen at a frequency determined necessary by mental health personnel. 2. The state has identified and provided the names of all suicide companions, which the state intends to call as witnesses for confessions and relevant statements against his own interest, which includes 16 correctional officers, 8 inmate companions, Warden Gallipo, mental health personnel, and Indiana State Police officers. The admissibility of a confession is controlled by determining from the totality of the circumstances whether the confession was made voluntarily and was not induced by violence, threats, or improper influences that overcame the defendant's free will. Carter v. State, 730 Northeast 2D 155-156, Indiana 2000. Citing Wilcoxon v. State, 619 Northeast 2D 574-577, Indiana 1993. The same test determines whether Miranda rights were voluntarily waived. See Gregory v. State, 540 Northeast 2D 585-592, Indiana 1989. Thus, the voluntariness of the defendant's waiver of rights is judged by the totality of the circumstances. See Allen v. State, 686 NE 2D 760-770, Indiana 1997. Certified, denied. 525 U.S. 1073 LED 2D 667 11S CT 807, 1999. An express written or oral waiver of rights is not necessary to establish a waiver of Miranda rights. See Haran v. State, 682 NE 2D 502-510, Indiana 1997. REHG denied. 4. The Fifth Amendment's privilege against self-incrimination applies to the states through the 14th Amendment. When a defendant challenges the voluntariness of a statement under the United States Constitution, the state must prove by a preponderance of the evidence that the statement was voluntarily given. In addition, Indiana Constitution, ART 14 provides that no person in any criminal prosecution shall be compelled to testify against himself. The Indiana Constitution requires the state to provide beyond a reasonable doubt that the defendant voluntarily waived his rights and that he voluntarily gave his statement. 5. The self-incrimination clause of the Fifth Amendment protects an accused only from being compelled to testify against himself or otherwise provide the state with evidence of the testimonial or communicative nature. Curry v. State, 643 NE 2D 963-968, Indiana Appellate Court, 1994. In order to be testimonial, an accused's communication must itself explicitly or implicitly relate a factual assertion or disclose information. ID absent custodial interrogation, there is no infringement of the Fifth Amendment rights identified in Miranda, and no occasion to determine whether there have been a valid waiver. The term interrogation under Miranda refers not only to express questioning, but also to any words or actions on the part of police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. Since police cannot be held accountable for the unforeseen results of their words and actions, the definition of interrogation can extend only to words or actions on the part of police officers that they should have known were reasonably likely to elicit an incriminating response. Curry v. State, 643 NE 2D 963, Indiana Appellate Court, 1994. 7. The defendant is being held in pretrial detention for his safety pursuant to court order. Inmates of the PLUS program and subsequently correction officers at the IDOC holding facility have been assigned to observe Richard Allen and record his behaviors, which has included documenting statements by Richard Allen. That the assignment of the correctional officers to replace inmate companions coincides with Richard Allen being provided with legal documents for his case. Therefore, it was determined no longer appropriate for inmates to provide companion services due to the gag order and discovery protective order. 8. That the defendant alleges all his statements subsequent to arrest should be suppressed for the reason that they are all involuntary due to the conditions of his pretrial detention, which they categorize as illegal coercion, either psychological or physical, in violation of his constitutional rights. Number 9. Statements by Richard Allen, which the defense seeks to suppress, are unsolicited and voluntary, like those in C versus State, where defendant made unsolicited statements while he was being moved from one part of the jail to another. Such statements was properly admitted into evidence. C versus State, 173, Indiana Appellate, 348363, NE 2D 1063, 1997, Indiana Appellate, Lexus 871, Indiana Court Appellate, 1977. 10. The defense has alleged that physical coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. The defense has also alleged that psychological coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. Number 11. That the defendant has not alleged that any of these statements are the result of interrogation by law enforcement while in custody, and the state would assert that Richard Allen is not being interrogated by law enforcement or any agent of the state during his pretrial detention, regarding the charges pending herein or regarding any other criminal activity. 12. The case law on application of the protections of the Fifth Amendment indicates that the absent interrogation by law enforcement or an agent of the state, the defense does not have a basis to challenge the admissibility of voluntary statements made by Richard Allen. 13. The state acknowledges its burden to show beyond a reasonable doubt that the statement was not obtained in violation of the Indiana Constitution or by a preponderance of the evidence that the statement was not obtained in violation of the United States Constitution. However, the state does not believe the constitutional protections allow for the defendant to allege that all statements during pretrial detention are the result of coercion directed against him. This posture requires the court to begin with an assumption that pretrial detention in IDOC by its very nature is coercive interrogation by a state actor, and thereby shift the burden to the state to present testimony to refute illegal coercion for every statement made by the defendant. 14. The defendant is making a blanket argument that all statements by Richard Allen are the result of improper influences based on defendant's mental state without having to address each statement and its unique circumstances. The defense argument ignores the case law regarding application of their cited constitutional protections by skipping over the threshold of showing or alleging interrogations by law enforcement or their agents. The defense motion expects the court to accept that all inmates, employees, and third-party medical or mental health personnel are acting as agents of the state, specifically law enforcement, with the purpose of illegally coercing statements from Richard Allen for his prosecution. The allegations and assumptions are absurd, unfounded, not supported by the motion filed or any facts or evidence. The motion to suppress all of Richard Allen's statements is another attempt by the defense to derail this case with conspiracy theories and inflame the public to believe the government has unjustly pursued charges against Richard Allen. 15. The state requests that the defense be required to identify the specific statements of Richard Allen that were illegally coerced and identify the state actor whose conduct supports the allegations of coercion and describe the conduct they believe to be either physically or psychologically coerced before the state is required to respond for further analysis by the court. 16. In the absence of specific allegations by the defendant as to each statement against his interest that is involuntary as a result of law enforcement interrogation, the state asserts that the defendant has not sufficiently identified statements subject to a motion to suppress. Wherefore, the state requests the court to deny defendant's motion to suppress statements filed on April 11, 2024, as failing to state a claim for relief under the 4th, 5th, and 6th Amendment of the United States Constitution and Article 1, Section 12, 13, and 14 of the Indiana Constitution, absent a more specific statement setting forth with specificity the statement obtained during custodial interrogation by law enforcement or their agent, and identifying the conduct by such state actor that would be psychological or physical coercion illegally and knowingly directed against Richard Allen for the purpose of inducing confessions or statements against his own interest. Respectfully submitted, Nicholas C. McClellan, Attorney, number 28300-08, Prosecuting Attorney. And now you're up to date on Deb's True Crime Notebook. Thanks for watching. Don't forget to like, ring the bell for all notifications. Please leave a comment because we love to hear what you have to say and your thoughts on the subject. And share this video with a friend. We'll see you next time.